Hello and welcome back to the Lawyer Talk, the podcast channel of BLawyers Vietnam. We are BLawyers Vietnam and we are delighted to be with you again in today's exposure. Today, we will be discussing a sensitive but increasingly important topic in the corporate environment, handling sexual harassment in the workplace. In practice, this is not only a legal issue, but also a matter of internal government, corporate culture, and dispute risk management. In this exposure, I will focus on three key questions. First, when is a conduct considered sexual harassment in the workplace for disciplinary purpose? And second, why do employers still file cases even when they have brought to take disciplinary action? And the third, what should employers prepare in order to avoid being caught off guard when such incidents arise? Moving to the first question, when is conduct considered sexual harassment in the workplace? First of all, it is important to clarify a fundamental issue. When a conduct illegally considered sexual harassment in the workplace? First, under Labor Code 2019, sexual harassment in the workplace is defined as any conduct of a sexual nature by any person toward another person at the workplace that is unwelcome or not accepted by the leader. And second, in terms of manifestation, sexual harassment in the workplace may be classified into two main categories. Quick record conduct, such as making proposal, requests, suggestion, threats, or coercion to exchange the sexual relation for any work-related benefits. Second, conduct of sexual nature that is not intended as an exchange but creates an uncomfortable or hostile working environment, causing harm to the physical or mental well-being, work performance, or personal life of the person being harassed. The third, according to labor law guidance, sexual harassment may take various forms including 1 is physical conduct, including action, gesture, contact, or any physical interaction with the body of a sexual nature with a sexual connotation. 2 is verbal sexual harassment, including spoken word, delivered directly via telephone or through electronic means with a sexual content or sexual implication. And 3 is nonverbal sexual harassment, including body language, or the display or description of visual material of a sexual nature, whether directly or via electronic means. Based on the above regulation, a common practical scenario arises when such conduct occurs during the company party or internal event involving alcohol consumption. Employers often question whether, in such circumstances, the conduct may still be considered sexual harassment in the workplace for disciplinary purposes. In the context, an important issue that must be clarified is the scope of the workplace. First, under Labor Code 2019, the workplace is defined as any location where the employee actually performs work as free or as assigned by the employer. And second, under Decree number 145, the workplace includes any location where the employee actually performs work as a free or as assigned by the employer, including location or places related to work, such as social activity, seminars, training sessions, official business trips, mail, telephone communication, interaction with electronic means, transportation arranged by the employer between the resident and the workplace, and communication provided by the employer, and other locations designated by the employer. Accordingly, activities such as company party or internal event organized by the employer or directly related to work may, in many cases, still fall within the scope of the workplace under applicable laws. However, in practice, determining the scope of the workplace is not always straightforward. There have been cases where, despite the conduct being considered inappropriate, the employer was unable to impose disciplinary action as it fell outside the scope of regulation. For instance, In one case, the conduct occurred in the roughly 8 p.m. on a taxi privately arranged by two individuals following an informal gathering. In this situation, the court considered the timing, location, and the nature of the activity and concluded that the incident no longer fell within the employer's scope of management. As a result, the disciplinary decision was declared invalid. Another factor that employers frequently question is the use of alcohol. Pursuant to Article 122.5 of the Labor Code 2019, disciplinary action must not be imposed on an employee who commits a violation while suffering from the mental illness or another disease that results in loss of awareness or the ability to control their action. Accordingly, cases where disciplinary action is not permitted due to loss of awareness or control do not include a situation where the employee has consumed alcohol. This is because alcohol consumption does not alter the nature of the misconduct and does not constitute ground for exempting the disciplinary liability for acts of sexual harassment in the workplace. Therefore, in order to effectively apply the legal provision in practice, employers must clearly specify in their internal labor regulation, first, the definition and the element for determining sexual harassment, and second, the scope of the workplace. In particular, for employers with 10 or more employees, the internal labor regulation must be in writing and registered with the competent labor authority. In the absence of such regulation, or if they are not sufficiently clear, disciplinary action in such situation may expose the employer to significant legal risks. Moving to the second question, why do employers still lose scale even when they have vowed to take action against sexual harassment? The answer lies in the critical factor, the labor disciplinary handling procedure. Notably, in many cases, employers do not flu because they incorrectly identify the misconduct, but because they fail to handle it properly. First, pursuant to Article 122 of the Labor Code 2019, labor disciplinary action must strictly comply with mandatory principles and procedures. Specifically, the employer must, through employer force, ensure the participation of employee representation organizations, ensure the employer present and right to present a defense, and record the entire process in writing minutes. These requirements are not merely procedural formality, but mandatory conditions for the legal validity of the disciplinary decision. In practice, there have been numerous cases where employers had clear evidence of misconduct but still flew the scale due to procedural violation. For example, in one case, the employer conducted a disciplinary meeting immediately after inviting the employee to a meeting, without answering the minimum notice period of at least 5 working days as required by law. The court opined that this violated the employee's right to defend, and therefore the dismissal decision was declared invalid. And secondly, another common issue related to improper signing authority. In one case, although there are valid authorizations, the internal labor regulation illicitly stipulated that only the legal representative had the authority to sign the dismissal decisions. Allowing another person to sign, even if valid under civil authorization, was considered by the court to be inconsistent with the internal labor regulation, rendering the decision legally invalid. Thirdly, in addition, employers should be particularly mindful of several other risks in disciplinary proceedings. One is taking disciplinary action for conduct that is not clearly stipulated in the internal labor regulation, or where such regulations have not been properly registered. Two is violating the statutory time limit for disciplinary action, which is generally 6 months from the date of violation. And the three is failing to comply with mandatory procedural requirements, such as the absence, the employee representation organization, or failure to properly document the proceeding. In practice, some employers have not established a grassroots trade union, yet their internal labor regulations require the participation of such organizations in disciplinary proceedings. This creates practical difficulty in compliance and may give rise to legal risk if not properly addressed. From the above, it can be seen that, in case of workplace sexual harassment, correctly identifying the misconduct is only the first step. The raised legal risk lies in whether the employer complies with the disciplinary procedure. Under labor law, even a single procedural error may render the entire disciplinary decision, including dismissal, invalid. Moving to the third question, what should employer repair to avoid being unrepaired when sexual harassment case arise? Look at the reverse two questions. A common issue emerged. Employers are generally aware of the risk, but lack a sufficiently clear system to handle them. In practice, current labor law mainly provides for a principle and procedure of discipline action, but do not offer detailed guidance on the initial steps of receiving, verifying, and handling sexual harassment complaints. As a result, many employers handle such cases on an ad hoc basis, leading to inconsistency and potential legal risk. Therefore, to avoid being reactive, employers should proactively establish several foundational elements. First, internal labor regulation. Under Labor Code 2019, provision on prevention of sexual harassment are mandatory content of internal labor regulation for employers with 10 or more employees. Such regulation must be in writing or registered with the competent labor authority. More importantly, the regulation must not only exist but must be sufficiently detailed to be practically applicable, including clearly defining prohibited conduct, the scope of workplace, and principles for handling violation. Second, internal procedure to be detailed in sexual harassment prevention policy. As the law does not provide detailed procedure, employers should proactively design a clear and structured process for receiving, verifying, and handling complaints. For example, it is necessary to clearly identify who is responsible for receiving complaints, how verification is conducted, and in which cases the matter should be referred to competent authority, particularly where the criminal element may be involved. Third, mechanism for confidentiality and protection of involved parties, which should also be incorporated into sexual harassment prevention policy. Sexual harassment cases often involve sensitive information. Therefore, employers must ensure the confidentiality of the complainant's identity while also safeguarding the accused's right to respond. In addition, in the current context, employers must pay attention to personal data protection requirements. Information generated during the handling process, such as messages, emails, or statements, may constitute sensitive personal data and must be processed in accordance with the legal requirements on purpose limitation, scope, and appropriate security measures. Finally, an important but often overlooked element is training and awareness. In practice, many situations do not arise intentional misconduct, but from a lack of awareness of appropriate behavioral boundaries in the workplace. Therefore, employers should incorporate sexual harassment prevention into internal training programs and conduct spirited awareness sessions for employees, particularly for management level. Such training should be practical and scenario-based, helping employees understand what constitutes inappropriate conduct and how to respond appropriately in different contexts. This not only ensure legal compliance, but also contribute to building a safe, respectful, and working environment. At the same time, it plays an important role in protecting the employer reputation in the long term. Ladies and gentlemen, we have now gone through 3 key questions. that employers commonly face when handling workplace sexual harassment cases, from identifying misconduct to complying with the disciplinary procedure and to building an internal system for risk control. We hope the insight provide you with a more practical perspective and useful point to consider in managing human resources within your organization. If you have any question or comment, please feel free to leave them below. For more information about BLawyers Vietnam, please visit our website with the link displayed beneath the Lawyer Talk podcast screen. Thank you for listening and see you again.